So hi, I'm Sam Goldstein. Just to underline the issue or the importance of just individual action, I was the director of legal affairs for B'nai B'rith for 2 years, recently stepped aside, and how this event happened was I invited David Bernstein. I'd read his book, liked the book, understood what was happening. He articulated the framework which I had sort of recognized, and asked him to come speak in Toronto. He came to speak in Toronto, came over to my house for supper. I talked to him about trying to put on an event. He put me in touch with David Steinberg. We then got in touch with Andrea Spindle, and that's how this event happened today. So it sort of underlines the importance of just individuals trying to do something. You don't have to have group action. You could have individuals coming together. It starts with one person. So as a criminal lawyer and as a lawyer, I think it's important to sort of look at some of the legal actions, how to respond to the issue. I think just to set this up for a moment, we as Jews, we've always believed in equality. The history of the 19th and 20th century was the expansion of equality. We had equality for women, for blacks, particularly in the United States. We had equality for the gay community. And something has happened now with our concept of equality. So the first person I want to introduce is Bruce Pardy to my immediate right. He's a professor of law at Queen's University, also the executive director of the Rights Probe. And Bruce, what's going on with this issue of equality? It seems to me that equality no longer means equality.
That's completely correct. So think about it this way. There are two competing versions of legal equality. And the first one, which you're referring to, is the idea that everybody is entitled to be treated equally. They're entitled to the equal protection of the law. That is, this idea embedded in Western legal systems that justice is blind, that the same rules and standards should apply to everybody without regard to who you are, what race you are, what religion you are, what sex you are, and so on. Okay, that's the first idea. The second idea is the opposite one, which is that different rules and standards must be applied to different groups of people so as to achieve equal outcomes. This is equity. So equal treatment and equity are opposites. You cannot have them both. They conflict. You have to pick one. And for a long time, the idea that we had was the first one. And now the idea is the second one. And that, largely, is the fault of the Supreme Court of Canada. And in particular, not exclusively, but the architect of this change, in large part, have been prominent, progressive, Jewish lawyers.
So I think when you're saying that, can you touch upon, and I think we've talked about Rosie Abella's seminal work, which sort of bridged that gap between thinking between equality as a universal application and then to equity being an outcome issue.
Yes, actually, Rosalie Abella is the first person that comes to mind, whose name you may recognize. So in 1984, this is long before she became a judge of the Supreme Court. In 1984, she was appointed to head a federal commission on employment equity. And her report contained an idea. And it led very shortly thereafter to the passage of a federal statute, the Employment Equity Act. The idea is this, that if a workplace or a profession or an institution contains within it a different proportion of people from some groups, as is contained in the general population, then that workplace or institution is discriminating. That is, it is racist or it is sexist. Now, mind this, that does not require any extra evidence. It is merely the fact of, for example, if you have this proportion of indigenous people in your institutions, and that percentage is lower than the percentage of indigenous people in the population at large. Therefore, by definition, that institution is racist. Right? And this idea gets embedded in the law, in the ways the Supreme Court of Canada interprets the equality guarantee in the Charter of Rights. There is one. And if you read the words, it looks like, it sounds like, it is giving us all the first kind of equality right. That is, blind justice, the right to have equal rules applied to everybody. And through the whole history of charter jurisprudence, from the very beginning, the Supreme Court of Canada has instead applied the Elmaleh idea, which is that the Charter requires substantive equality, meaning equality of outcome between groups. Now, here's the kicker. If an institution or a profession or a workplace contains a lower percentage of certain kinds of groups, then that's racist. If you have too few of certain people, that means, by implication, that you have too many of other kinds of people. Because it always has to add up to 100. So consider the legal profession. The Law Society of Ontario, just for example, has adopted, like so many other institutions, adopted this idea. The Law Society of Ontario maintains the legal system in Ontario, the legal profession in Ontario is racist. Now, here's what they mean. They say, well, there aren't enough of these kinds of people. And by implication, there are too many of these other kinds of people. They wouldn't put it this way, but here is what they mean. There are too many Jewish lawyers. That is the implication of the case that they are making. And among the people, among the strongest advocates of this ideology embedded in the law, and especially at the Law Society, as I said before, are progressive Jewish lawyers.
So just before I move on to Howard for a moment, Bruce, so it seems to me that what you're saying is it's not so much that our laws per se are the problem, but rather it's the people, the judges, who have been interpreting laws. Is that fair to sort of sum up a little bit of what you've been saying?
Yes, that I think that's fair. But so let's just put it this way, though. Your statement is absolutely correct, but it's even more fundamental than that. So you read the Charter. It has words. It says you have freedom of speech. It says you have equality. And you think, well, therefore, I have freedom of speech. And I have equality. No, you don't. Because the Charter means nothing other than what the court says that it does, right? So just a very quick example. You read freedom of speech. You think, I have freedom of speech. Well, just take a very simple example. If you go up to somebody on the sidewalk and you say, your wallet or your life, I have a gun in my pocket, okay? That's speech. That's not protected. That's an assault. It's a crime, okay? But the Charter says freedom of speech. The point is this. There's a line somewhere inside the provision that's not articulated. And where the line is and what the provision means is not up to you, and it's not up to me. It's up to the court. So whatever the court says it means, that is what it means. And so our equality provision today means substantive equality. It means equity. It does not mean that you are entitled to the same rules as everybody else.
So, Bruce, you certainly underlined the primacy of the judicial position, and I want to get back to you a little bit later about maybe how to. Sorry, thank you. You certainly underlined the primacy of the judge, and you've, by implication, I'd like to get back to you about how we select our judges and the importance of that. But just for the moment, Howard Levitt, I don't think I have to introduce you, employment lawyer, writer for the National Post. And Howard, Bruce seems to be setting up that our our courts and my language have been captured, and we've got problems in the courts, but yet, how do you think, notwithstanding a little legal terminology, despite the fact that we may have a captured court system, do you agree with that, and how do you deal with it, and how do you see fighting, in particular in your area, unions and institutions?
Well, give me a mic. Let's start with
Oh,
that.
okay, sorry.
Okay, thank
I
you.
thought there was one. Get one next to you, just to the left.
Okay, you got that.
Give me back my microphone. Okay.
Bruce and I met about a year ago. We fought to try and get more of our people as benchers of the Law Society and fighting it back against the woke establishment that historically dominated.
I should point out that I was a bencher, and then Howard defeated me in the last election, but he replaced me.
I voted for me. So that's how
Me too.
that's how Bruce and I met. But we lost to the woke establishment. And I thought, a lot of these people are running to be benchers in the woke establishment because they want to be judges. Now, the first 40 people who won, because they all voted as a slate, were what I'll characterize again as the woke establishment. The next 40 in line, because we ran as a slate, were us. And now there's 7 of us a year later as benchers. Why is that? Other than one? Because they all got appointed as judges. So that is a good example of who is being selected by the Prime Minister as judges, to really underline the point that Bruce is making. And that's not anomalous. That's been the case for some years, that the traditional government has been appointing what we'll call the woke left to the judiciary among the candidates that are put forward to them. So don't think that justice, I don't think anyone in this room does think that justice is blind. Justice is driven by the views of the people who are on the bench and what they think public policy is. Because public policy plays a large, significant role in how the law is interpreted and how the Charter in particular is interpreted. So
Yeah, so let's go to the next. Thank you for that. Thank you for that. But let's talk now about your firm.
Sure.
You have been retained by a number of different Jewish organizations. So how do you see, despite the fact we may have a captured court system by progressive thinking lawyers, how nevertheless do you go about trying to fight these issues?
Okay, I will. And I would, one more item.
Sure.
Following up from Bruce before I finish, Rosie Abella, who's a charming woman, a delightful woman, but she's been disastrous for our community and are disastrous for the development of theology of the courts because of affirmative action, which way back when, before I was the National Post, I was writing for the Toronto Star before they told me I was too right-wing to write for the Toronto Star, and that was the end of that before the Post came into existence. And I could only write for the Star if I stopped writing about political issues and unions. And then the Post came and saved me, and I was able to write for the Post and write what I wanted to write. But I wrote way back then, and that was 28, 20, 30 years ago, how ultimately racist affirmative action is for all the reasons that Bruce described. Now I'll answer your question. Okay. Let me break this into certain components. First of all, employer obligations and rights. If employers permit anti-Semitism or any form of racism in their workplace, they can be sued. They could be sued for under human rights legislation. They could be sued for constructive dismissal, which means a fundamental poison to the work environment for Jewish employees. They can be sued for intentional infliction of nervous shock, which means intentionally inflicting or negligently inflicting mental stress. They can be sued for intentional infliction of economic interest. I'm giving you the names of various what we call torts, things you can sue for that employees are not availing themselves enough of. But these are all things that Jewish employees in this case in the workplace can sue. And constructive dismissal is effectively saying, you've made the workplace untenable for me, and if you've effectively fired me, and you have the remedy of a wrongful dismissal action. But on top of a wrongful dismissal action, simply put, which is up to 3 to 30 months severance pay and full remuneration for whatever you would have earned in those 30 months, and the 30 months, I can't bore you with a lecture on the law, but that's the range of wrongful dismissal damages in the country right now. Because of the nature, the reason for the constructive dismissal, you can also sue for mental distress and even punitive damages. Now, people think human rights have some real impact, and they don't. You're much better off suing for constructive dismissal or wrongful dismissal than going to the Human Rights Code, because in human rights, there's no cost paid at the end. It goes on for years. It's not as much in the public eye as a wrongful dismissal case. So I say to my employer clients, it's much better to have a human rights case against you than a wrongful dismissal case. And from your standpoint, it's much better for an employee to sue for wrongful dismissal or constructive dismissal than to sue for, than to take an application to the Human Rights Code. Notwithstanding that, our firm has taken Fred Hahn and CUPE to the Human Rights Commission, impotent as that remedy effectively is, because union employees can't sue for wrongful dismissal. They cannot sue for constructive dismissal. They can grieve, and the union decides what grievances are advanced. And they can say, well, you haven't fairly represented me as a unionized employee. You won't take my case. I've got a very good grievance. I'd say about, generally speaking, now I'm not talking about this issue, generally speaking, about 95% of justifiable grievances are never advanced by their union for reasons of cost and otherwise, and unions are allowed by the Labor Relations Board to pick their grievances. And there's an exception to that if you can say as a union employee, well, they didn't act free, arbitrarily, discriminatorily, or in bad faith. You've got a pretty good case to say it was discriminatory if it's an anti-Semitism case, especially against your own union or against your employer. But the actual statistical success rate for duty of fair representation cases is under 1%. So it's an impotent remedy. Why is that? Because the Labor Board says that unions are amateur bodies, they're not a group of lawyers, and they're entitled to make mistakes. So there's a shot, and this is probably a pretty good area, because it really is discrimination, which is, I suppose, an exception, but it's not a strong remedy. But we brought the case notwithstanding that for several reasons. One, because CEJA helped us bring the case and funded it to some extent. Secondly, because it brought some publicity to the issue. And thirdly, because it became somewhat of a rallying point for Jewish CUPE union members and other union members to know there is some form of remedy. Now, it will wind its way through the Human Rights Tribunal for years. That's how long these things unfortunately take. But it's one way of fighting back. But employees' rights in a non-union workplace that I've already discussed is much more powerful. Now we talk about what employers' obligations are. First of all, they don't want to be sued for constructive dismissal or wrongful dismissal or even human rights. But what are their rights if you've got an anti-Semitic employee? What are their obligations or if Jewish employees are facing anti-Semitism in the workplace? Well, to fire the employee in question. And beyond firing anti-Semitic racist employees in your workplace who discriminate against Jewish or other employees, what about if you have an employee attending one of these pro-Hamas hate rallies? I hate the expression pro-Palestinian hate rallies. Every one of them is a pro-Hamas hate rally. They all shout from the river to the sea and other genocidal slogans, so I don't let people get away with calling them pro-Palestinian hate rallies. That's not what they are. But leaving that aside, what do you do if you have an employee of yours attending a pro-Hamas hate rally? Well, if the person is in management, if they're client-facing, if they're public-facing, then that impacts on your brand as an employer. That impacts on your reputation as an employer. You have the right to fire them for cause without severance. Immediately. And by the way, in employment law, if you don't do it immediately, you're forsaking your right to do it at all because it's called condonation. You lose your cause, any cause, whether it's theft, whatever. If you don't fire right away, you've condoned the misconduct. So you have to fire right away as the employer, and you fire without a penny of severance. Now, what if they're not public-facing or client-facing or managerial, and therefore don't affect your brand? They're in the mailroom. I say fire them anyway. They may or may not have a case. You may be able to argue cause. You may be able to argue it tarnishes your brand, especially if you catch them on social media, then it is cause. Let them fight you is my approach. Some courts will say that's cause for discharge, whatever their position is. In any event, you can still fire them because the Human Rights Code does not protect ideology. The Human Rights Code protects religion, national origin, various other things, but it doesn't protect political opinion. So they have no protection if they're racist. In fact, they have absolutely no protection if they're racist under the human rights legislation. So that's employers' obligation and what employers' rights are. I'll speak quickly about union employees, which I touched on a moment ago. They've got this duty of fair representation, which is a rather impotent remedy, and they can grieve through the grievance procedure. But what if your union itself is a CUPE? And there's some decent unions on this subject in this country, and most of the public sector unions are not all of them, but most of them are awful. You can disassociate from your union if you're particular. Some of the union locals in CUPE are apoplectic about what's going on, are enraged, are really concerned, don't want to be tainted with that, so they can associate with steelworkers or any other union. They could decertify if there's enough members, if 40% sign membership cards, a particular local, they can then get an application to the labor board for a decertification vote. At that point, majority wins. Or Jewish members could run for the executive of the union. Now that's tough in an institutionalized organization, a massive organization like a CUPE, but there's enough of a groundswell right now against people like Fred Hahn that it's not inconceivable anymore. So those are some of the remedies that we can pursue in those various forma.
So just, I'm going to go to David Elmaleh, but when I get back to you, I just give you a little time to think about it. I'd like you to tell us a little bit more about, whether you see the future in defending the Jewish community within the courts being class action suits or these individual suits. So I'd like you to contemplate that for a moment, then I'll get back to you. So David Elmaleh, let me introduce you for a moment. Probably the less recognizable face on this, probably the best looking as well on this panel. But I too recognize what Barbara Kay was saying about Michael Tepper and the tenacity and the detailed work that he's done and doesn't get the recognition. I think I had asked him to do stuff for B'nai B'rith when I was asking him to do work for B'nai B'rith when I was, as I was saying, the director of legal affairs. So I recognize his great work. But another person I think who doesn't get any recognition is David Elmaleh, who, when I had asked and hired, retained for B'nai B'rith to work on cases, and he's done tremendous work, doesn't get the recognition. I was involved in a defamation suit against the Law Society, and he represented me and did excellent work, and I was ultimately successful in that suit. And thanks, David, for your help on it. So I want to give a little recognition for David Elmaleh with
Thanks, Sam.
and his partner, Aaron Rosenberg as well. They've done stuff for Brooke Goldstein and so on. But David, I want to get to you now. Now, we've talked about equality and the changing issue. We've talked, Howard was talking about, discrimination, but let's talk now about some of the problems within the Human Rights Act. As Howard was talking about, you've got these heads of heads of prohibited grounds of discrimination. You've got nationality, you've got religion. You specifically did a case against U of T and the Graduate Student Society. We were ultimately, I think, successful, not as successful as we would have liked to have been, but it was that incremental type of achievements that you can achieve. Let's talk about that. Give us the big story about what that case was about, the problems that you had within it, and then the outcome.
Thanks so much, Sam, and thank you, everyone, for being here today. Just to start, we are in the midst of war. There's a war in Israel on the northern front that just opened up on October 8th, and it intensified recently. There's war on the southern front. There's war on the home front. There's also war for global Jewry, and the fronts are in the media. The fronts are in the courtrooms. The fronts are in universities. They're behind the scenes, and they're in front of the scenes. Last night, I had the privilege and the pleasure of meeting 3 soldiers that were on the Kisufim base on October 7th, that lost their friends, that lost their comrades, that lost their families. And the message that they gave to us in the diaspora, in global Jewry, is to continue fighting, to continue struggling. And it's the same thing that I tell my 7-year-old daughter, which is we can do hard things. We can continue the struggle, and we can continue doing the work. Win, lose, or draw, there is tremendous value to stand up for the principles that you believe in, to stand up for right, to stand up for truth. Before I get into the U of T case, I want to just mention very briefly the different fronts that we have that we can use at our disposal. And one of them, and Barbara mentioned it, and everyone here, is in the courtroom. And it's important not to look the other way. I had the privilege of representing an IDF veteran. His name was Shai DeLuca. He's an interior designer, and he was grotesquely defamed by a notorious anti-Semite and somebody who operated an establishment called Food Vendors. And what this individual with this company did was they defamed him publicly. And you know, when we talk about setting up our own shingles and opening up our own businesses and the window shopping, these days it's all online. And when somebody goes after you online and they attack your reputation, when they slander your family name, when they slander your business, my message to you is to please consider everything, of course, and get legal advice, but stand up. And this was a 3.5-year battle where ultimately there was a sitting judge. It was Justice Papagajo, and she ruled in our favor, and she found that calling someone a terrorist just because they are an IDF veteran, it's inappropriate, it's wrong, it's anti-Semitic, it's malicious, it's directly malicious, and also in the law of libel and slander, you can also prove malice by showing a reckless disregard for the truth. And that's our role. It's to stand up for the truth and to demonstrate to these folks and the institutions that the ones who are directly malicious need to be held accountable, but so too the individuals and the organizations and the institutions that are simply being reckless. So there are avenues to succeed in the courtroom, but we do have to be selective because bad facts make bad law. The second ground, not just in the courtroom, but touching on it, it's symbolic. And one of the things that my team managed to do is we took on and we represented a small winery, you may have heard of it, called Psagot Winery. And we decided, together with our clients, to defend itself when a federal court judge said that putting a product of Israel label on its bottle of wine was false and malicious and deceptive just because that winery was over the green line. Well, if it's not part of Israel, what is it a part of? And what we ended up doing was we intervened at the Federal Court of Appeal, and we got not only intervener status, but party status. And we were able to put in evidence establishing that, hold on a second here. We understand that there's international conflicts. But at the end of the day, we're talking about a winery that not only employs Israelis, but that gets its power from Israel, that pays Israeli taxes, that is subject to domestic Israeli law, that is subject to international Israeli customs law, that has the IDF forces protecting it, that has near sovereignty over the area. And we managed to establish that the product of Israel label was not false or misleading or deceptive. And if we put some additional information on the label, that we can do it. Now, that was a legal victory, but I don't want to focus on that. What I want to focus on is that over the course of those 5 years, what we were able to do is galvanize the community. Instead of the boycotts, we had boycotts. We put out one press release, and all the Israeli wine and all the kosher wine in the local LCBOs in our areas, they were all sold out. And guess what? Can you guess what the LCBO did? It restocked the shelves. It wanted to make some money. So there's value in symbolism as well, even in what we consider to be low-hanging fruit. Now, going to the grad student case, so I had the privilege of representing a graduate student who was forcefully, in essence, because he was a student, he had to be part of the union. And as part of that union, there was something called a BDS caucus, which wouldn't allow Jews in, which wouldn't allow Israelis in. And we took it and we did the internal complaints process. And I'd be interested even in everyone else's comments on this, but it was just awful. It was a terrible process for the students. We could tell from day one, that maybe we'd get a Pyrrhic victory, but at the end of the day, it took 4.5 years, and the person who started as a first year ended up graduating before we got the decision. Now I have about a dozen similar complaints across universities and colleges in Ontario, and you see the same process playing out, which is that these institutions, I think intentionally, perhaps it's just bureaucratic, but they're slow-walking these complaints. And ultimately, and this goes back to the idea of intents and contextualization, they're ultimately saying that there is this distinction between Judaism and between Zionism, and anti-Semitism and anti-Zionism. And there could very well be a distinction in certain instances. But why is it that when there's conflict in Israel, anti-Semitism goes up here at home? Why is it that people are piling on the only Jewish state? And it's impacting us. And, I'm somebody, and, I consider myself a religious Zionist. I wear my kippah. And what I would love to see, actually, is for us to move a little bit away from these national origin type of arguments under the code and to move a little bit more to religion. Because in my view, you don't have to be religious to appreciate the connection between Israel and the Jewish people. Under every chuppah, we talk about internal Jerusalem. And if we forget Jerusalem, we forget our right hand. At our seders, when we pray, when we bless our children, it is completely embedded in our fabric and in our religion. And in my view, notwithstanding some other things the Supreme Court has said, the famous case Amsterdam, which was out of Quebec, that went to the Supreme Court about religious freedoms. It was a case about a sukkah, whether it can be on a balcony or whether it has to be on the main thing. And there were rabbis on each side that were talking about what the halacha was, what the Jewish law really was. And what the Supreme Court says, it doesn't really matter. As long as you have a sincerely held belief on reasonable grounds, then that should be protected.
So David, just to move forward a little bit, because we have a limited time, ultimately what happened is you went through the process. I think it's important to point out, long process, you kept to it. Ultimately, the the administration found, I think overturned the lower decision, but they found that there was a discrimination on national origin, and then withheld 11% of the budget that they were giving over to the graduate students. So they were denied the 11%. Not a complete victory, but I think it was a symbolic victory. Before I get to Bruce, get back to Bruce about the selection of judges and so on. One of the ideas that people talk about, you had problem, and thank you for talking about the importance of religion. I think it's an important point, and our Supreme Court's ignoring that right. One of the issues you had is whether to proceed by national origin or by religion. And there's a belief now that if we implement the International Holocaust, what does the R stand for? Remembrance Alliance, I think it is, the IHRA, that by adopting that definition, particularly the definition dealing with the double standard, that would prove to have that would show anti-Semitism. We've talked a little bit about that issue. What do you think about that? Will it help?
I think it will help. I think the challenge is that no university in the country will adopt it because they think it unnecessarily or unreasonably infringes on freedom of speech and to criticize sitting governments, the Israeli government, etc. I think it's an uphill battle and it's a challenge, but we need to keep pushing the envelope. And as a final point, I think there's tremendous value in advancing these types of arguments. And the case in point is the U of T encampment decision. I was involved as one of the intervening nonprofit Jewish organizations there. And ultimately, the outcome was helpful in the sense that the encampment was disbanded. But what the judge did was decided the case on the narrow basis of property rights and found that there wasn't sufficient, evidence of anti-Semitism, et cetera. And, in the decision, there were some comments that, reminded me of what some of the presidents of the universities in the U.S. said in Congress about contextualizing things. And the judge actually said, well, there isn't sufficient evidence of anti-Semitism. We're keeping Jews out of the encampments because we actually had Jews in the encampments. And some of them lit Shabbat candles Friday night there. So, when you tell us that there are these incidents, that they must have been isolated, it must not be systemic. So I think the message is we have to keep pushing it. But from a public interest standpoint, we have to get to the point, either as individuals in specific cases or as organizations and institutional support, we have to get to the point where we are creating the evidentiary record, where we are putting forward this evidence and we don't let other people fight our battles. Because in that encampment case, it was the right outcome. But the reasons regarding anti-Jewish hatred and anti-Semitism were problematic. But at the end of the day, we weren't able to disturb the record because it wasn't our case. It was the university's case. So we need to get to a point where we can make real impact on that stage, where we can tailor the evidence, where we can bring out the truth and shine a bright light on it. Because we are in an age where, I don't want to say truth doesn't matter, but it's not being emphasized or valued as much as perhaps it used to be, and that's the TikTok generation. So.
Just on the IHRA, I know, again, when I was with B'nai B'rith, I don't want to keep going on about that, but we at B'nai B'rith were trying to get a lot of institutions to adopt the IHRA. I know that's a big push now within the Jewish community. It's coming up again. I think it's important to point out, if you're involved in any of that there are, by and large, you have to be very careful about how organizations adopt it. So let me give you examples. There are 11 operational definitions of anti-Semitism. Only one of them deals with the double standard. Ontario adopted the entire IHRA, the whole kit and caboodle, all 11 definitions. Saskatchewan, you take a look at what they did, and they're not legally binding, these adoptions, but they just said, well, we adopt that anti-Semitism is discrimination against Jewish people. So they accepted the first definition of anti-Semitism. Now here's the problem. Unless you adopt all 11 definitions, it's meaningless. And I'll be quite frank, a little bit of Chatterhouse rules here. Internally with B'nai B'rith, I was opposing those people who just said, well, let's just adopt it for the sake of adopting. I said, it's useless. It has value if you adopt all 11 definitions, because then you could say the double standard is tantamount, but not equal to, anti-Semitism. The second thing I think it's important is that there is a lot of pushback, and I think some legitimate people may not like to hear that, about the free speech aspect of the IHRA's definitions of anti-Semitism. And the way I suggested we handle that, and again, it's the double standard issue, is it's true that not all criticism of Israel is anti-Semitic, but in the law, at least, with the double standard operational definition of anti-Semitism, you could argue that it is a rebuttable presumption. So in other words, it raises a scent of something wrong, and it'd be up to the other party to say, no, that's not really what you may think it smells like. It's something more innocent. So that's what we call sort of a rebuttable presumption. So I think the way we have to treat the adoption of the IHRA is by saying, if you're going to adopt it, great, adopt all 11 or else it's useless. And the way to deal with the any legal blowback about the double standard in terms of free speech is to say, listen, we're not saying it is anti-Semitism. We're just simply saying it raises suspicion. It's a rebuttable presumption. And therefore, in law, you could say, listen, they've allowed the encampment. Let the university prove that they weren't allowing the encampment for reasons other than sort of anti-Semitism. So that's an important takeaway, I think, when you're dealing with the IHRA. But we're going to go to Bruce and then Howard, then we'll open up because there may be questions that some of you may have. I hope someone asks about the importance of freedom of religion. But Bruce, so Howard pointed out that many of the people who got involved on the sort of oppressor-oppressed slate of benchers ultimately became judges. Papa Giorgio, who was the one who did your case, was one of those people. It's not just within the judges, although I want to point out, I also want you to talk about adjudicators within all the administrative, provincial and federal administrative tribunals, and then in regulatory tribunals. So how do we then try and change the judges? How can we do that?
Okay. So let me say this first about the judges. We have some good judges in Canada. But as an institution, it's going woke. And if you think about the title of this gathering, Woke Antisemitism. It's a good title, but it's also redundant. Woke is anti-Semitic. Like there are not different flavors of woke, some of which are not anti-Semitic. It is by definition that thing, for reasons that Barb and David alluded to. And the process of appointing judges and adjudicators is a political one. One of the things that Canadians love to point out about how bad the U.S. is that the U.S. process of appointing judges is very public, it's very open, it's very contentious, it's very political. It is a struggle, it's a power struggle. And in contrast, we like to say that we don't, ours is not political, okay? That's baloney. What it is not transparent and not contentious. Appointing judges and adjudicators is a prerogative of governments in power. And they appoint in accordance with their own criteria, their own people who share their ideology, and in accordance with a sort of an internal backroom, back channels kind of process. Now, there is the appearance of openness about it, but really that's just trimmings. And you will find over time, I think, although there are some exceptions, but the pattern has been this, that the characteristics of our judges do not differ greatly depending upon the political party that appoints them. In other words, the liberals and the conservatives and the Democrats, where there is a democratic government, tend to appoint the same group of people. You could see this through the Harper years. The Harper regime appointed a handful of judges to high courts, and until the very later stages, they appointed judges who were progressive. And so my message would be on judge appointments and on adjudicator appointments, you've got to get your hands dirty. You have to make the thing contentiously political. You have to get involved in the back channels and the back rooms. You have to put together lists. You have to put pressure on the politicians. You have to make them feel the heat and make them believe that they do not have a completely free hand to be pushed in the direction that they are now being pushed, and they go without resistance, and we are going in the wrong direction.
I want to get to Howard. We only have about 5 minutes, and Andrea's told me that. I have time?
Yeah, we
Oh.
break at 11:30.
Oh, 11:30,
We
oh.
have 2 mics, so we're going to go to the audience.
Okay, great, okay, so, Howard, I asked you to talk about, class action versus individual, but I don't want to limit you to that, so you could respond to anything if you want.
I would anyway, but okay. Ideally, class action is better than individual actions because you have more resources and you can take a more systemic analysis of what the issues are. The problem is it's first to the post. Whatever law firm jumps in quickly gets the class action. Other law firms can't. So you don't get necessarily the most appropriate law firm, and I'll just say nothing more than that, taking the class action cases.
A law firm that does class actions, at least has done one of them in the past.
There are some very good class action firms. I would have rather have taken the cases against the universities than the one that took it, to put it mildly. Now, that doesn't mean that individual actions aren't very useful. David's talked about his own experience with individual actions or action against CUPE, although probably not much will come of it at the end of the day. And because it's human rights, it's going to be largely behind the scenes. At least it gives some, I've talked about this earlier, some ability for Jewish CUPE members to coalesce behind and realize it's not just them, it's not just individuals. And also individual actions, statements of claims are public. And in these sorts of cases, it's not necessarily what happens at the end, and oftentimes never gets to the end for various reasons, but you get in a libel-free format to say whatever you want in a statement of claim, because you can't be sued for what's in a statement of claim or a statement of defense. And that permits you to set out very clearly precisely what is going on. And the press is allowed to publish it. And I'm delighted to hear that Rob Roberts is being honored. He's doing admirable work as editor-in-chief of the National Post, and the Post has been very good about, and the Sun, to a lesser extent, has been very good about publishing these stories. So that allows the Jewish community to galvanize around information they may not otherwise know about. And to the extent a reporter can write about a story that's happening in the community, a synagogue bombing or whatever, there's much more you can say in a statement of claim beyond that little episodic issue. And go into quite some depth that the press is then able to talk about without any fear of libel, without any fear of a lawsuit. Now, just about the universities for a second, the encampment were atrocious, but they weren't just atrocious because they were permitted to occur. They were atrocious because of how they ended. First of all, U of T let it go on for months and did nothing about the anti-Semitism that was ripe and rife within the encampment. But then when they ended it, I said, good, finally, I thought to myself, I hope the protesters stay, the police pull them away and throw them in jail or start levying fines. The U of T didn't let that happen. They made a deal with them. They gave them absolute amnesty for all of the criminal offenses committed within the encampment over those months if they just left peacefully. And Windsor was even worse, because the Windsor resolution gave funding to terrorism. It gave positions that the university then adopted on anti-Zionist issues. It was atrocious what they agreed to, which is why so many people have withdrawn funding from the University of Windsor. I hope it, like Ryerson, like TMU, goes down as a university. Now, another thing I want to say about that, I was teaching employment law to judges from Saskatchewan, Alberta, and Manitoba this week out in Saskatoon. And a judge came over to me and said, you know, Mr. Levitt, you're a hypocrite. I said, well, maybe. What have I done? What am I being accused of today? And he said, well, you wrote in favor of Jordan Peterson's Freedom of Speech Act form at the Supreme Court. You talked about how it was suppression of free speech. But 2 weeks earlier, you supported Sullivan Cromwell's position of big U.S. law firms, position they should not hire people attending these Hamas hate rallies. I said, I don't see the contradiction. well, that's not freedom of speech. No, wait a minute. Bruce's point earlier, freedom of speech has limits legally. You don't have the right to shout out hateful slogans, racist slogans, in violation of human rights legislation, for example. And my firm and many others in the city won't hire anyone who signed that TMU petition, that terrible anti-Semitic scream. And happily, a lot of racists signed their names to that. And some of them did it anonymously, so the Attorney General, and applauds the Ford government, said, we will hire Ryerson students whose names are not on the petition, but we asked them at the time, did you sign the petition even anonymously, and let you know that if we ever find out that you did even anonymously, you will be fired for cause as soon as we find that out, for lying to us now about it. And of course, in the States, when Ackman said, oh, I want to get the names of all those 22 organizations, of those hundreds of students from 22 organizations sign the petition, so they will become unhirable. And everybody else joined in. Well, we're doing the same, and that's some power that we have to say that anyone who attends these hate rallies will not be hired, they'll be fired for cause, and anyone who signs their names to these anti-Semitic petitions of various forms and various contexts will be fired for cause or will not be hired. Anyway, that's what I said to this judge who wasn't very happy at my response.
Good for you. Let's go to the audience.
I'm going to ask the first question as I
Okay.
pass this on. Based on really what Howard was saying, I've been wondering, can the Jewish community, either collectively or individually, sue the university or the university presidents in Toronto, in Windsor, and elsewhere where these encampments were allowed to continue?
I want to actually respond to that because something very interesting is happening right now. A number of us brought Canary Mission to Canada. Canary Mission, for those who don't know what it is, they're an organization, largely in the States, but in England, and they go to these hate rallies and encampments and capture social media profiles of those shouting out anti-Semitic slogans. And then they create a profile and pump it up on social media, so when anybody ever Googles that person's name, they're up at the top. And they have a picture of them shouting something awful. And guess what happens to them? They get fired. And good people like the people in this room will make sure that anyone they know will send it to their employers. And if they don't get fired because they're not employed, well, when they apply for a job, they don't get hired. Or maybe they get hired, but shortly thereafter, somebody in the organization sees that they're there and they send it to the employer and then they get fired. And that's a good disincentive to people attending these Hamas hate rallies or doing, or on social, not just the hate rallies, but on social media, saying things that are anti-Semitic. So, Canary Mission's first act in Canada after it came here was to publish the identities and social media profiles of those in the U of T encampment. And they found that over 150 of them were professors. So some of us are now about to meet to talk about how to pressure Gertner, who's at least nominally Jewish, titularly Jewish, to fire these people. And yes, they have tenure, but tenure doesn't entirely immunize people from discharge. For example, if a tenured professor committed a rape, they'd be discharged. Their tenure would not protect them. And of course, a lot of the professors don't have tenure. And what about students who broke the U of T academic code who are covered by Canary Mission because they've given us the proof we need? What about getting them expelled from university with a mark on their record so they can't, so for 5 years that will appear and therefore no other university will hire them? That was done to Bill Shavis decades ago when I was at U of T with him. I won't bore you with that particular direction. It would be boring, but I won't waste tender time with that particular story. But the point is that U of T has done it and can do it. And so a group of us are getting together to talk about how we can accomplish that and pressure the university to deal with these miscreants in their midst.
Hello.
Hi.
Hi. Can I ask my question?
Okay, one, who's speaking?
Yeah,
I
I'm
can't-
right here.
Okay, here,
Hi.
one, and then two, sorry, ma'am.
Thank you, everybody, for your work. So here's a question about professional associations. So in social work, there is any number of social work academics who have been in the media even because of their social media justifying October 7, this kind of thing. So what happened is there's one social worker who has just been awarded a distinguished social work designation by the Ontario Association of Social Work. They ask people to submit, vote for people and submit, and they pick somebody. And this is somebody who, right on his Instagram, he has a post that justifies October 7. He has written on medium.com an essay which pathologizes Zionism. And so the question is there any recourse when you have it's public facing, it impacts on the brand of social work. They're effectively condoning that conduct by recognizing and celebrating somebody who has done this. And is there any recourse?
So I think Bruce is going to talk about, but let me just comment as well. Do you want to say something? After you got three people, so let me just first say that listen, I think something can be done. It's not necessarily legal. It's something which I did in 2019. I came up with the idea of getting lawyers together to run as a slate to try and take back the Law Society. I and Bruce helped with that. And we were somewhat successful. We were able to get the Law Society to repeal a statement of principles. A statement of principles were these progressive ideology, right? So the first thing I say to you is it's not always a legal solution. Mm-hmm. Sometimes it's just simply a political solution, or small p. I'm looking at David Bernstein because he was talking about that. So I think it's just a matter of getting together, and if you have a regulatory body, try and take over the regulatory body. That's first and foremost. Bruce,
it's captured. It's captured.
It's
well,
captured.
Then you're right. We're fighting a resurgence, and to use that sort of war gaming terminology. I like war games. But you're right. It has been captured. Now you've got to fight to recapture it.
Right. So this is the bitter truth. The institutions are captured. That one you're talking about, the judiciary is captured. The legislature is captured. We live under a managerial state, and those institutions are captured. And those institutions are powerful. And one reason they're powerful is that the legislatures have made them so. And the other reason is that the courts defer to them. Don't expect too much of the law. If you're thinking that, we have this problem, but the law will protect us because the law is solid. It's written down in black and white. It's what it's there for. That is not true. The law is a cultural phenomenon. The law is a political phenomenon. If those two things turn, you're in a lot of trouble. So the better approach to that kind of problem is to do as Sam suggests. Don't expect the law to fix that, because that institution has a lot of power and is given deference by the courts and is given probably a broad mandate by the legislation that creates it. So the better thing to do is to take it back.
Howard?
Well, I just finished the Jordan Peterson case, and he was unsuccessful at the Supreme Court in overturning the decision of the College of Psychologists. The College of Psychologists have, or your board of social workers, have a lot of power to make whatever decision they want. And the court is only going to set it aside on a scale of highest of deference to the supposed expertise of the administrative body in question. That is the law right now. I know Bruce has written considerably about that law and been quite critical of it, but that is the law. So really what you have to do is try and recapture the organization in the next election. In the meantime, as occurred with Jordan Peterson, the College of Psychologists, and by the way, they can't find a psychologist right now. Re-educate Jordan Peterson. That isn't public. They can't find anybody. So I'm sure they will. They'll find some of their fellow travelers yet, but that's why there's been this delay. But the point is that it is now embarrassing for the College of Psychologists you can make it, hopefully you can politicize and make it embarrassing for the Social Worker Association in the same way by
Media.
publicizing it.
Media.
Well, running a group of people, media, but just to bridge what Bruce was saying and Howard's talking about Jordan Peterson, when Jordan Peterson first went to the court to argue that his regulatory body didn't have the jurisdiction to discipline, or not even discipline, to force him to engage in that re-education, his judge was Paul Shabas. Paul Shabas was the former treasurer of the Law Society who brought in the statement of principles. Why in the world, and it wasn't Howard, why in the world Jordan Peterson's first lawyer didn't ask that judge to recuse himself?
And she didn't tell Jordan Peterson that fact.
Yeah.
He would have obviously, and he told me, he would have challenged it immediately.
Two of the three members of that panel were ideologically driven,
Right.
historically.
And I'm surprised you didn't try and argue ineffectiveness of counsel when you tried to judicially review it, but we could leave that issue alone. But I was just, so there sort of, goes to the importance of getting involved in your regulatory body or your association or your wargamer group. And the fact is that our judges are being politicized. Let's go to over here, if you don't mind, ma'am.
So that's actually...
Okay, back to you.
What I was going to ask is, based on what you guys were saying today, talking about woke judges that are up and coming or that are here, and based on things like we just saw the U of T, the judge didn't punish anyone, how are we supposed to feel safe as, never mind Jews, but just people with morals and values? How do we go forward and not fear for what the future is going to entail based on all these woke judges or people that aren't doing anything?
Keep fighting, don't give up.
And don't not be fearful. I mean, the situation that you're describing is real. And so we have a real problem, a huge, real problem. The first thing to do is to understand that it exists, and don't bury your head in the sand. There are things we got to do, and they're hard things.
I guess it just feels that if the judges are the ones that we're now having to deal with and face with woke and whatnot, the layman person...
Well, you got to go back. So this could be a generational thing. I mean, you may have to start with your kids. So to enable them to grow up in a way that does not allow them to be indoctrinated with the same ideology.
Howard wants to say something as well. Sorry, I don't want to cut you off, Bruce, but...
As a community, we are timorous. We've historically been timorous. We're fearful. We're not tough. I'm just going to give a stupid example, but when I was a kid in Hamilton growing up, where being Jewish meant you were in fist fights every day of the week virtually, you killed Jesus, etc. But then I came to Toronto Jewish summer camps, and it was just a much tougher group in Hamilton. We're just not tough as a group. Israelis are tough. We have to be tough. Keep your mezuzahs out there. Wear your Jewish stars, even if you wouldn't have otherwise. Be tough and be resilient and show that you aren't being cowed. Because bullies will stand away when you're tough. And they will come at you when you appear weak and timorous.
Let's go... Sorry.
Can I just jump in for
quickly, though, because I want to get to members of the
30 seconds. Just some other things you can do is just let's try not to narrow the scope, just to you or just to somebody else or just to social work. The issue with the social work, that's not just a social work problem. That's a societal problem. That's a problem for all of us. And,
We'll get to education. This is law.
that's the next panel.
Sir, the individual in the mask.
Hi, my name's Mark Goldberg. I do a lot of work on social media. A couple years ago, together with John Kay, took down Laith Marouf and those issues. On Thursday, some of you may be aware that Arthur Wilczynski resigned as special advisor on anti-Semitism at the University of Ottawa. I made the mistake of saying something very controversial on social media, saying that the loss of your leadership and participation will be felt, and that triggered a reply, "Hey Mark, how many dead kids is enough for a bloodthirsty weirdo such as yourself? 10,000, 100,000? I think we can argue about whether I'm bloodthirsty. My kids would probably agree with him that I'm a bit of a weirdo. But in looking at his social media activity, he had a minute earlier replied to Arthur saying, "Good riddance, Jewish ISIS scumbag." Now, I looked this guy up. His name's Sean J.K. on social media, but he actually promotes himself as a rural Newfoundland lawyer. So a member of your profession. I went to the Law Society of Newfoundland's directory. Turns out there's only 3 people named Sean who are members of the bar in Newfoundland. One of them happens to be Sean J. Kavanaugh. So it's Sean J.K. from Calvert. His Twitter ID is Guy from Calvert. So on Friday, I wrote a 5-page letter to the Law Society of Newfoundland. I'm just wondering, and I guess, David, maybe this is for us to discuss over coffee, are either of those comments actionable? Is being bloodthirsty defamation, is being called a Jewish ISIS scumbag actionable for Arthur?
David obviously answered, and I have something to say as well.
The short answer is it's complicated. I think it is, but that being said, it would probably fall within the category of fair comments, something like an opinion. And our law does recognize hyperbole as protected speech. It can be defeated by showing evidence of malice, etc. The big challenge, though, that at least I'm facing in my defamation practice now is that in response to these types of allegations, to these lawsuits that we're launching, the defendants, what they're saying is, hold on a second here. I'm not saying anything that other government leaders haven't said just yesterday, that members of Congress haven't said, that members of the UN, that the head of the UN hasn't said. So that's putting us in this sphere where something that was once considered egregious hyperbole is now making its way into mainstream dialogue. So what I would say is that, it's arguable. But one other thing to note is that the Supreme Court very recently came down with a decision that was heavily criticized for many reasons, but talking about counter speech. That if somebody puts something online in the public town square, then somebody else arguably can respond to it, and there's some added protections there because, just because of the nature and the occasion where it's discussed. So I'd say we're trending in the wrong direction on that front. But that doesn't mean that you shouldn't seriously consider, opportunities available to you to protect your reputation.
Yeah, and to follow up with that, and I may be diverging a little bit from the panel, and I may be diverging what people may want me to say, but listen, I'm a very big free speech opponent, and let me give you the framework of why I'm saying that. Free
Proponent
speech,
or opponent?
Proponent of free speech, sorry. And I have a tendency for malapropisms. And the reason why is that, when we talked about how to fight the oppressed ideology and the anti-Semitism, I believe the best way of doing it is by going back and re-engaging in the principles of the Enlightenment and liberal Western values. That has always served us the best as a Jewish community. And so when we're talking about these issues, a bit of a distinction in the Jewish community now is, well, we need to have more diversity, more inclusion, more equity. And the problem with that is you give more power to the concept of inclusion, right? If you start asking for, we need to have a Jewish envoy or an envoy against anti-Semitism, well, inclusion means you have to have an envoy against anti-Islamophobia and anti-Palestinian, right? So, and then you have what's going on now in our country is you have the anti-Islamophobia envoy basically indirectly arguing with the anti-Semitism envoy, right? We don't want to have inclusion. What we should be going back to is our fundamental principles of dealing with tolerance and talking about pluralism. That's what we really need. That's the best way of fighting it. And again, when I was, dealing with these cases with B'nai B'rith, I always tried to argue that what's good for the Jewish community has to be good for Canada, and what's good for Canada also has to be good for the Jewish community. We should be talking in general values, general principles that apply to everyone, all ethnic communities, religious communities, everyone. And sometimes you may not like the fact that this person is calling you names, but his right to call you a name gives you the right to call him a name, right? And listen, as Jonathan Kay pointed, it may just get ludicrous, but don't be so quick to say, I don't like what you have to say, right? Because denying that person to say what they want, no matter how stupid or hyperbolic it may be, denies you that very right. So let's be careful sometimes with how we want to apply the law.
Can I just say that? I totally agree. I totally agree. Reverse cancel culture won't solve your problem.
Howard wants
Right.
What he said to you is over the top. It's not within the realm of the kind of debate just being referred to. It's over the top. I think it's exactly the right thing. Complained to the law study. Now I had Dimitri Lascaris, who those who would know, a vicious member on the other side, say some horrible things about me, and I complained to my law society about him, or his law society in Quebec, and they did nothing. But the point is, not just complain to the law society, send the complaint to the local media in Newfoundland, make sure the guy never gets another client.
He's aggressive. Let's go back over here. Let's go back over here.
Hi, I'm Shauna Small.
Hello.
Hi, Sammy. First, I want to say thank you. Thank you to all of you for your clarity, for your courage, for standing up for humanity. Thank you, thank you, thank you. And so I am a principal, and I'm also a Zionist and warrior, and I'm part of Jaffa. And I really see, so one thing that was said earlier that was really concerning is, well, this will pass, this too shall pass. And I really, really don't think that this too shall pass. I think, and you all have consolidated that thought in me, that this is systemic, and it's right through our education systems, and right starting in kindergarten. It's not just in university, this is within our public education system. And as we know, kids that come through the education system, they become our future, they become our lawyers, they become our judges. And this is a systemic issue that all of us need to be fighting this war. With that being said, I've seen the rise of anti-Palestinian racism. And one thing you said, I think, Sammy, you said human rights doesn't protect ideology, which is great. I want to know how that can be applied to anti-Palestinian racism, because according to the Canadian Muslim Lawyers Association, anti-Palestinian racism is, you're an anti-Palestinian racist if you question anything around the ideology of being a Palestinian. So their Nakba, their return to Palestine, all of that, which we see as part of Hamas's chapter. Hamas is a terrorist ideology. So how can we apply human rights protection? If human rights doesn't protect ideology, how then are teachers being suspended for anti-Palestinian racism?
So I'm going to answer your question this way. Okay. There is going to be 2 panels on education, and those panels will deal with it. You may not like when I'm about to say this, but again, I think free speech is the answer, which is if you don't like your right, to support anti-Palestinianism is to support an ideological vision of history or visionist history. So speak out against it. That's all. It's not a legal use. I mean, again, free speech, by supporting it, you're furthering it, and that's the way to do it. Let's go back to this side of the table. The very tall man over here.
Morning. This has been a great panel. So, in short, I volunteer with a security organization called Magen Haru, which we are on campus, just to make sure that, let's say we're right next to campus, just to make sure that the Jewish kids and others feel safe. But in short, I had a very interesting experience, because when you're out there with the rallies and you see, the Hamas mobs, you wonder why the police don't actually just stop them. Or like for example, a Hamas mob can move from campus and just take over the street, and all of a sudden, that street's blocked off, and traffic has to find another way to get where they're going. And you're wondering, why isn't the police not doing anything? And I was talking to a gentleman, and unfortunately, I didn't get the chance to get the full context. But the person that looked to be the captain, we had a very brief conversation. And essentially, this gentleman from Toronto Police said that according to, I believe, the criminal code or something of that nature, they don't consider From the River to the Sea to be hate speech. And therefore, because there is no hate speech occurring, technically, it's just free speech, their hands are tied. So that's why they are forced to essentially let these Hamas rallies occur until someone smashes a car or does something, and that's when the police will step in, which is why you'll probably notice that a lot of it is reactionary, and they're not actually sort of just stopping a Hamas, like a hate speech entirely, which I think is weird, because if KKK were protesting downtown, I would say, what the hell's going on? So my question is, from a legal perspective, I do wonder what can be done and why this is the case.
So let me answer it. So first of all, there's two issues here. One is the issue of policy for policing and what's something, the legal definition of hate speech. So first is, it's quite clear, and as Karima Saad here, I know she said that she wanted to come and we tried to make space for her. She and I have talked about this. I encourage you to go speak to her about it, because one of the things that she's been noticing, and I was commenting with her, is that initially after about the G20, whatever, 10, 15 years ago it was, the police changed from interfering and trying to prevent these demonstrations to facilitating a demonstration with the hope that they'll just simply move on. Right? And they've been adopting that policing technique with the demonstrators, being naive to think that they'll just simply move on. I think, as Karima would confirm, again, speak to her about it, she's noticing that when there's a bit of a change now, and particularly when these demonstrators are interfering with the police or property, particularly buildings, they'll start getting involved in arresting and breaking up. So I think that's what's happening, and I think it's the wrong policing model that they're using, but that's a political issue dealing with coming from the mayor and so on. So I have 2 more minutes. The other issue about whether From the River to the Sea is remember, there's no hate crime in Canada. What it is there's one offense dealing with public incitement to hatred towards an identifiable group, which is what we all commonly refer to as the hate law, and the other one is dealing with incitement to public disturbance, right? Listen, you only have what we consider to be the first one if you're saying kill Jews. And that's the reason why, is because we value free speech. There are instances across Canada, about a year ago, you have the Chaput case in Quebec, and you have another case in Saskatchewan, where the courts have said, one person in the Chaput case in Quebec said that 2018 will be the year of Nazis or Nazification. The judge in that case clearly saw that as meaning killing Jews, right? We haven't, I think to say From the River to the Sea is analogous to 2019 is the year for Nazification, right? But there is a hate unit in the Ministry of the Attorney General. It's populated by some very good lawyers, some Jewish lawyers, Robin Flummerfeld, Jamie Kluklach. These people are very smart. I was a Crown attorney at one time, so I grew up with them to some extent, and I know them. Both of them are used to go across Ontario for very important cases, but they haven't decided to charge people yet. And I think it's a political issue to try and convince the Attorney General that they should be charging, because we have analogous cases which would allow the police to charge people underneath the hate to identifiable groups. That connection hasn't been made yet. But yes, I think it is a hate speech, and I think it's contrary to, I think it's 319, because of the analogy you can make to the Quebec case. But I have a case out where in Gravenhurst, where a woman came out, and Barbara Kay might be interested in this, started protesting these transgender women, drag queens, giving classes to young children on how to carve pumpkins. She was charged with one of the offenses of causing a disturbance, right? And to me, it's just she gets charged, but what they're doing they're not getting charged. So it is very frustrating, believe me, to see the disparity in how police are charging people. But you're right to be outraged. There is, I think it is, as I say, contrary to that section of the criminal code. But it's going to be up to the hate crime speech and the Ministry of the Attorney General to make the connection to the Shabbat case, and I certainly tried to do that when I was involved more in the Jewish community. I'm now simply a simple criminal lawyer, as I like to say. But yes, it certainly could be.
Sam, can I jump in just to give a couple of practical steps very quickly? So number one, document everything, whether it's by video, whether it's memos to yourself, it could be texts, it could be emails. Legal processes take a long time, and you're not going to remember necessarily every single detail. So one thing that you and everyone here can do is to document what happens at these rallies, at these protests. That's number one. Number two, you're absolutely right. The police in general will not actively get involved unless they are of the view that there is an immediate risk of bodily harm, of serious bodily harm, or property damage. And they've demonstrated that since the first rally, I think it was on October the 9th. But another thing you can do is to try and blend the civil and the criminal. And this is one thing that we managed to do when there was a very significant protest outside a couple of synagogues in Thornhill on March, I think it was 4th or 5th, and then March the 7th. And one thing that we did was we sent a legal letter to York Regional Police, to Toronto Police, and we laid out there what we thought would happen, clause by clause under the criminal code, what we thought the laws would be broken, including face coverings, including bylaw violations. And I'm telling you, I've sent a lot of legal letters over the last 14 years. I've never gotten a response so quick from the Director of Legal of York Regional Police. And the reason is because if you put them on notice before something happens, then they could potentially be legally culpable from a civil perspective if there was foreseeability of harm and there's an increased risk of harm and they're made aware of it and they're warned of it, and then they fail to protect those communities. And what ended up happening at those rallies is that the police, first of all, they called in a lot of extra people, and they did keep the peace. There were criminal acts that occurred then, including many slogans. But what ended up happening is, as a result of that, as a result of the community being galvanized, the city council in Vaughan ended up passing a bylaw prohibiting protests within 100 meters, I think it was 100 meters, of religious institutions. So, when we're looking, I would encourage you all to look holistically at all of these troubles. And it is very concerning. But at the same time, there is not one solution. We need to draw in from every discipline, from every avenue, from all of our collective resources and our strengths. And we can do it together as a community, and that's what we can do. And we shouldn't just simply complain, but we need to act. And we need to use some bad experiences to incentivize ourselves to move forward and proactively deal with the problem.
Thank you very much. Thank you very much. I want to say